nations have signed on, but not the nuclear weapons holding nations, not Israel.
So, just watching the Breakfast Club power here, Dr. Jill Stein and Dr. Butch Ware on Green Party policies, the Breakfast Club. Check it out. It's really cool. I want to talk about U.S. v. Nixon. U.S. v. Nixon. This is such a cool case. There are so many incredible quotes. Let me give you some background information first. So, U.S. v. Nixon, 1974. This is going to lead to him resigning. He's going to resign like a couple weeks right after it. U.S. v. Nixon, 1974. The Supreme Court is going to unanimously, 8-0. So Rehnquist had recused himself, but out of the 8 that had voted, they unanimously ordered President Richard Nixon to deliver tape recordings and other subpoenaed materials related to the Watergate scandal to a federal district court. And this is such an incredible case because you got the Trump v. U.S. case, you got the Trump immunity case, right? Which is saying that the president is immune in some areas. This is decided July 24th, 1974. This is related to the Watergate scandal, the late stages of the Watergate scandal, amidst an ongoing process to impeach Richard Nixon. There is precedent limiting the power of any U.S. president to claim executive privilege. This is an important precedent. Chief Justice Warren E. Burger wrote the opinion, joined by Justices William O. Douglas, William J. Brennan, Potter Stewart, Byron White, Thurgood Marshall, Harry Blackmun, Lewis F. Powell, and Burger, Blackmun, and Powell were actually appointed to the court by Nixon during his first term. Rehnquist recused himself, like I said, from before. So this is an incredible case because they're going to give him a subpoena, and it didn't even have to do with Nixon. So Nixon is just going to claim presidential immunity. And he didn't have like any follow-up. He didn't have like any more than that. So when they're sitting there explaining ultimately what had happened is they're going to compare two things. They're going to say whether or not a president has a generalized immunity. Can you just say, well, I'm the president, I'm immune. You know, you can't look at my communications. George W. Bush and Karl Rove and company, they deleted all their emails. And what they thought that Nixon's mistake was that he recorded everything. And Nixon was a history man. He wanted to make sure that history remembered his presidency. So he was recording everything because he was being historical. But there's this case, it has to do with Watergate, and 7 of the people have, they're in his cabinet, but Nixon is not named in the indictment. But they need some evidence to be presented to the grand jury about the Watergate break-in. And then they said, Nixon says, I'm the president, I don't have to share you with my communications. He puts out publicly a bunch of the tapes, and he says that these are the relevant portions of my tapes. So he puts out a public, and then people are pissed off about that, with the way he was talking, a bunch of cuss words. And so he kind of, I don't want to say fucked up, but the Supreme Court says, no, that's not good enough. You can't just throw out some tape recordings out to the public. We want to hear all of the tapes. We want to hear every tape that you got. We want to hear all of it, all the time. They even say that you could come in camera, which is in private quarters. So when the judge goes to the judge's chambers. So they're saying, Nixon, you can bring the tapes in. We could go there in the judge's quarters and we can look at what's going on. And they said, no, that's not good enough. You can't just publicly put out edited tapes. We want this. Why? Because a criminal investigation is more important than a generalized immunity claim. It is more important to get the evidence. The public has a right to every man's evidence. The public has a right to every man's evidence is both Brandsburg v. Hayes and it's U.S. v. Nixon, 1974. And so that's the general background, I believe. They subpoenaed they had indicted the 7. They subpoenaed him. So he got delivered a subpoena, and they said, you need to turn those tapes over. And he says, no, I don't want to. And he resigned. He didn't want to turn the tapes over so badly, he just fucking resigned. And so what it looks like, I mean, he could have claimed Fifth Amendment privileges, right? And just a generalized immunity, he could have actually said more words than just, well, I'm the president, I don't have to talk to you. He could have been like, I'm the president and there's national security reasons. They even said that there's several, diplomacy, in the name of diplomacy, you might have heightened privileges when it comes to presidential communications, when it comes to the military, when it comes to national security secrets. So if he could have claimed, well, I have diplomatic secrets, or I have some things about diplomacy, or I have some things about the military. So if he would have just says, I'm immune because it has to do with the military, because it has to do with the national security secrets, or it has to do with important diplomacy, then he would have been excused. But he didn't say that, or his lawyer didn't argue it, that just a generalized immunity. I think it's amazing because essentially the courts are saying that the rule of law applies. When the courts, the biggest thing that the courts do is resolve disputes between two people, and they prosecute crimes. So the president not turning in the evidence that he had, they said that he has to turn the damn thing in, and then he's ended up going to resign. So in a way, I guess he showed them, right, by not turning it in. Well, I ain't going to turn it in. I'll just quit the job. What do you think about that? And it's also incredible that Berger, Blackman, and Powell kind of turned on him, right? He appointed them, and then they're like, no, you got to do this. And they know about the scandal, they know about the papers, and they know about the impeachment proceedings. So it's like a perfect storm, right? All this shit was hitting Nixon at the same time. So what I like about it is it's the rule of law. You have the criminal prosecution is more important than just some generalized immunity. Later on, in an interview, I forget the title, it was like a famous Frost v. Nixon. So you had Frost was interviewing Nixon, and Nixon said, if you're the president, it's not illegal. Which is an interesting, that's called the Unitary theory of government. And I think it's kind of true, but kind of not. To me, you can't enrich yourself, you can't do emoluments, you can't infringe upon, you can't commit crimes. There's a lot of things. But I think that if you always said that as the president of these United States, I did A, B, C, and D, then I think you're covered. But if you're just being a private person doing your own private shit, you know, well, I went to get an ice cream cone, I didn't like that woman's stupid face, so I shoved the ice cream cone in her face. And then I laughed and I said, I'm the president. I can do as the hell as I please. I'm immune. That doesn't help America. That very much hurts America. You did it for your own private ego, your own whatever, your own private aggrandizement. So, let's get into some of the specific details here. Ryan Quest recused himself, as he had previously served in the Nixon administration as assistant AG. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. Compulsory process, that comes from the Sixth Amendment. Only recently the court restated the ancient proposition of law, albeit in the context of a grand jury inquiry. I kind of like that word, albeit, because it's pronounced exactly as it's seasoned. It's like, that's Greek. Only recently the court restated the ancient proposition of law, albeit in the context of a grand jury inquiry, rather than a trial, that the public has a right to every man's evidence, except for those persons protected by a constitutional, common law, or statutory privilege. So there you go. You got three outs right there. If you say you have a statutory privilege or something in the code, you know, there's freedom of the press, and there's a Kentucky congressman that actually was driving drunk, but it said that when he is in session, you can't get him if he's coming and going to the place. So he was able to point to a law on Kentucky books. Oh, it might have even been a constitutional one, but apparently you're allowed to drive drunk when you're driving to the legislature. Hey, I was driving to make some laws, and damn it, I got to deal with all these assholes, so I drove drunk. which is interesting. So they're disagreeing. U.S. v. Nixon 1974 says that no, you don't have a unitary president. No, you can't do anything illegal. And that's correct. That's right. You have to be able to say that you did the same, and we can't tell your intentions. So you could say, well, I thought she was a Russian spy, so I had to shove the ice cream in her face just to make sure she. No, you didn't. No, you didn't. You didn't think she was a Russian spy. You weren't doing anything for America. She pissed you off. You didn't like her face, and you just wanted to hurt somebody. That's not good. That's a crime, and they should be convicted for it. When I think about, there's a great little story about what's his face, U.S. Grant, and so the president of America, Ulysses S. Grant, he is going to drive fast. He's speeding. This is back in the days of horse and buggy, but he is just flying down the road with his horses. People are having to jump out of the road, and a police officer says, "Hey, stop it! Stop what you're doing." And then U.S. Grant kind of slowly comes to a stop, and he's like, "Ah, damn it!" And he accepts it. There's a ticket. He goes there. He put up like $50 for a bond, and then he didn't show up to court, and so he just forfeited his bond, and then therefore everything's fine. It's all fine. It's all cool. So he didn't show up for court, so he kind of was a dick about it, but U.S. Grant got a ticket for speeding. A regular police officer, and it was a black police officer too. So that's incredible. That's such an incredible story that no man is above the law. We are a nation of laws, not of men. And even if the president is speeding, it doesn't matter if you're rich or poor. It doesn't matter if you're powerful or not. If you're speeding, then you should be pulled over and you should be. So that's awesome. We should have the rule of law, and it's good that U.S. Grant kind of, accepted it. If it was like a big crime where he could see like jail time or something, then maybe he wouldn't have just been like. And then people were sitting there, they're pissed off. There's other people of his entourage that had to go to court, and they're all pissed off about it. But he defended the black man and was like, hey, he's just doing his job, and we're speeding. And then you're the president, so you're setting a bad example. You're the president. You should be following your own laws, right? You're the executive branch, and you're driving down like, if you're in an emergency, if you're doing something, but just freewheeling, lollygagging, freewheeling. What are you, some kind of freewheeling, lollygagging McGee? What's that damn movie, man? What's Eating Gilbert Grape? No, that other one with the Ferris Bueller. Damn it. What are you, some sort of lollygagging Ferris Bueller? To ensure that justice is done, it is imperative to the function of courts that compulsory process. Only recently, the court restated the ancient proposition of law, albeit in the context of a grand jury rather than a trial, that the public has a right to every man's evidence, except for those persons protected by a constitutional, common law, or statutory privilege. So he could have come up with a common law privilege, which you're just making it up at that point, right? Constitutional law. You could, there's the Fifth Amendment, there's other privileges with communications between wife and husband, client and attorney, your priest, the penitent and the priest. Then there's some other. So you have privileges that you could have alleged, but he was just like, I'm the president. Hey, guy, I'm the president. I don't have to listen to your. Take that subpoena and shove it up your ass. I'm the fucking president. I'm allowed to speed. I'm allowed to shove ice cream in people's faces. On the other hand, the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantee of due process of law and gravely impair the basic function of the courts. On the other hand, the allowance of a privilege to withhold evidence that is demonstrably relevant. You have evidence. It is totally relevant to this case. Give us that evidence. That cuts deeply into the guarantee of due process of law. It absolutely does. You have to develop a fact. So if you have, 4 eyewitnesses, say you have Phil Greeny and then that female, they're all at Gary Gonzalez's house. Gary Gonzalez owns the house and the land, but Phil Greeny just keeps on, staying there. He says he's been there for 4 years or some shit. Robert Pickerel, Phil Greeny, that female that was at his house, and then that male that was across the way, who I think was Noah, but I'm not 100% sure. There's 4 eyewitnesses, and then there's a material witness that Phil Greeny, he's going to say that he's got a photo in his hand. He's got a photograph of the series of events that happened that day. So if you got a photograph, you saw what was happening, you are a material witness, and therefore you should be called to trial. To not call the material witnesses, to not give a damn about the facts. You don't care about establishing the truth. You don't care about objective truth. Well, we captured you, and since we kidnapped your body, we get to rape you all the live long day. That's not fair. It's like Jesus Christ. You just hope that Ann Kelly and Michael Gonzalez and that Michelle Quintana doesn't ever run a damn morgue. You got the rigor mortis, right? So you don't want... Basically, if they got the body, they'll keep raping them, so they're a bunch of wannabe necrophiliacs. You got to figure out the facts of the case. You have to get to the bottom of things. You got to figure out the facts of the case. The truth is objective. JFK's head goes back into the left. Who was the shooter? I don't know, but he came from that direction over there. All right, let's get on this because I got a lot to read. The constitutional need for production of relevant evidence in a criminal proceeding is specific and central to the fair adjudication of a particular criminal case in the administration of justice. Absolutely. Without access to specific facts, a criminal prosecution may be totally frustrated. So when Joe Canty had threatened my life, and we're going to pretend that he didn't do that because he lied. Well, he's a liar. He didn't say that he did. There you go. Well, case closed. It's my word versus his. How can you tell one way or the other? That's ridiculous that you would take one person's word and act like it's the word of God, and then take the other person's word and act like they're just making shit up. When it's the opposite. It's the opposite. He's the liar. He lied right there on stand. He perjured himself right there on stand, which I would never have done. The constitutional need for production of relevant evidence in a criminal proceeding is specific. He threatened me and my dogs at my home, so I did a Section 13. So me knowing Colorado law is what fucked me. Because I knew Colorado law, and I also believe that you get to defend yourself. That comes from natural law. It's common sense. The constitutional need for production of relevant evidence in a criminal proceeding is specific and central to the fair adjudication of a particular case. Criminal case in the administration of justice. Without access to specific facts, a criminal prosecution may be totally frustrated. No absolute immunity. Nixon, you do not get absolute immunity because it cannot prevail over the fundamental demands of due process in the fair administration of criminal justice. The generalized assertion of a privilege must yield to the demonstrated specific need for evidence in a pending criminal trial. I like saying demonstrative, demonstrably, but it's demonstrate, right? So it's like codify, demonstrably. No absolute immunity, Nixon. The fundamental demands of due process of law. We have an accusation. We need to go through the process because we need to figure out the facts. And once we get the objective facts, then we need to get the objective justice. And justice is equal and exact. Justice is equal and exact. That's Thomas Jefferson. That's his inauguration, which, America, I know you know that. I know you know all this. I'm just reminding you of it. The generalized assertion of a privilege must yield to the demonstrated specific need for evidence in a pending criminal trial. So they're saying that when you have a trial and you're trying to establish the facts, the public has a right to every man's evidence. If you witness the thing, you got to come in and show what evidence you have, even if it's to say you didn't see anything. The public has a right to every man's evidence. So you not having evidence, well, I closed my eyes and I put my fingers in my ears and I went, la, 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 la. Okay, so you saw nothing. You were there at the scene, but you saw nothing. Because if you saw something, maybe everybody can lie in different ways, maybe, I don't know. I just feel like if you have a dispute between person A and person B, each witness brings something to the table, even if they're liars. then you know that they're liars. And it's like, why are they lying? You know, what's up with that? You know, but presuming they all tell the truth and they all have a different perspective, they may have seen something. They might have seen it in a different way. They might interpret it differently. But it's like Mark Twain says, you got to establish the facts first, and then you get to distort them at your leisure. But you must establish the facts first. Let's see here. We have elected to employ an adversary system. This is all U.S. v. Nixon, 1974. So if you need some good quotes for your trial, then this is what you should say. We have elected to employ an adversary system of criminal justice in which the parties contest all the issues before a court of law. The need to develop all relevant facts in the adversary system is both fundamental and comprehensive. The ends of criminal justice would be defeated if judgments were to be founded on a partial or speculative presentation of the facts. The ends of criminal justice would be defeated if judgments were to be founded on a partial or speculative presentation of the facts. The very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts. So they're corrupt pieces of shit. Michael Gonzalez and Ann Kelly did not want to know the facts. They didn't want to know the fucking truth at all. They think they work for the cops. So if the cops kidnap you, they think it's their job to cover his fucking ass, to lie, to distort the truth, to not distort it, to lie, and to use the lie as if the lie is truth. Don't even come to the facts. Don't even figure out what the objective truth is. You got your truth, and he's got his truth, she's got her truth. There is no objective truth. You know, we're all just a bunch of fucking assholes lying up a storm. No. Some of us are telling the truth. If anything, some of us are pathological truth tellers. The very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. Absent a claim of need to protect military, diplomatic, or sensitive national security secrets, we find it difficult to allow Nixon to not produce the tapes, even for in-camera inspection, with all the protection that a district court will be obliged to provide. So in a way, they give Nixon so many outs here. They could say he could have filed a motion, and he could have filed a motion saying, you know, the communications are protected because there's a military aspect, a diplomatic aspect, there's national security secret aspect to the thing. And they're saying, even if you use that as an excuse, or are kind of embarrassed by some of the language you use, you're saying, bitch and fucking douche canoe and twat waffle. Who uses twat waffle? Maybe you don't want the public to know that you say the word twat waffle, and so therefore you can go into the judge's chambers and show them the evidence, and then they'll protect you that they're obliged to provide. Nixon does not have an absolute unqualified privilege when we need to do justice in criminal prosecutions. Nixon does not have the president. So if the president doesn't even have an absolute unqualified privilege, then how the hell can anybody else? How can a judge or a legislature or a cop or anybody else say that they have immunity? Immunity. Rights and privileges and freedoms come from the Bill of Rights. So in a way, we all have some kinds of immunity. We have the right to speak, and we have the right to the press and peacefully assemble. To do justice is a function of the court. We Americans have our historic commitment to the rule of law. This is nowhere more profoundly manifest in our view than the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. Guilt shall not escape or innocence suffer. Which is just saying the guilty should be convicted and the innocent should be let go. You should let the innocent go free and you should convict the guilty. A grand jury had returned indictments against 7 Nixon aides, including former AG John Mitchell as part of the Watergate investigation. Leon Jaworski, a special prosecutor appointed by President Nixon, and the 7 defendants wanted access to audio tapes of conversations recorded by Nixon in the White House. Nixon argued that the concept of executive privilege gave him the power to withhold sensitive information such as his little private historical tapes from other government branches in order to maintain confidential communications within the executive branch and to secure the national interest. Chief Justice Warren Burger said that the president didn't have an absolute unqualified privilege to withhold information. We conclude that when the ground for asserting privilege as to the subpoenaed material sought for use in a criminal trial is based only on the generalized interest in confidentiality, it cannot prevail over the fundamental demands of due process of law and the fair administration of criminal justice. The generalized assertion of privilege must yield to the demonstrated specific need for evidence in a pending criminal trial, Burger said. Burger delivered the opinion of the court. Number one, this litigation presents for review the denial of a motion filed in the district court on behalf of the President of the United States in the case of United States v. Mitchell et al., D.C. Crim number 74110, to quash a third-party subpoena duces tecum issued by the U.S. District Court for the D.C. pursuant to Federal Rule Criminal Procedure 17C. The subpoena directed the President to produce certain tape recordings and documents relating to his conversations with aides and advisors. The court rejected the President's claim of absolute executive privilege, of lack of jurisdiction, and of failure to satisfy the requirements of Rule 17C. The President appealed to the Court of Appeals. We granted both the U.S. petition for certiorari before judgment number 73, 1766, and also the President's cross petition for certiorari before judgment. Because of the public importance of the issues presented and the need for their prompt resolution, on March 1st, 1974, a grand jury of the U.S. District Court for the D.C., the District of Columbia, returned an indictment charging 7 named individuals with various offenses, la-di-da-da-da. And then it kind of goes on, bullshit, bullshit, bullshit. Let's get to the quotes, right? The first contention is a broad claim that the separation of powers doctrine precludes judicial review of a president's claim of privilege. The second contention is that if he does not prevail on the claim of absolute privilege, the court should hold as a matter of constitutional law that the privilege prevails over the subpoena duces tecum. You're not going to do a subpoena duces tecum? Nixon, oh yes, you're going to do my subpoena duces tecum if I tell you. The court is supposed to define for themselves what powers they have in relation to the 3 branches. The President's counsel, as we have noted, reads the Constitution as providing an absolute privilege of confidentiality for all presidential communications. Many decisions of this court, however, have unequivocally reaffirmed the holding of Marbury v. Madison that, quote, it is emphatically the province and duty of the judicial department to say what the law is. You're going to say, we're not going to say what the law is? Oh, hell no. We're going to tell you what the damn law is. So they went all Marbury v. Madison. They went all the way back to, what was that, 1804? The court held that neither the doctrine of separation of powers nor the generalized need for confidentiality of high-level communications without more. So basically, God, they give him so many outs. It's incredible that he lost this case. Can sustain an absolute unqualified presidential privilege. The court granted that there was a limited executive privilege in the areas of military or diplomatic affairs. They also mentioned earlier that, state secrets, national security secrets. So when it comes to diplomacy, when it comes to military, when it comes to national security secrets, then you have privilege. You could say, hey, I'm the damn president. I'm talking about the military. Go fuck yourself. But they're saying if it has nothing to do with diplomacy or the military and national security secrets, and there's a criminal trial, you got to show a subpoena. And at the very least, you got to explain why you're not. You got to say what your privilege is, and the court has to agree with the privilege. So when the police and when the courts didn't get Phil Greeny, they didn't arrest him, they didn't bring him into court. When the cops ignored my subpoenas, I paid for the subpoenas, and they didn't deliver the subpoenas. They're not doing their job. They don't care about the truth. They know that they're protecting their criminal buddies. These are corrupt motherfuckers, and they are corrupt to the fucking core. It sucks that you're a victim of a bunch of, fucking private citizens, but then when the damn court wants to try to say, hey, Anne Frank, no, you're the guilty one, Anne Frank. The victim, the one who is a victim of fucking 200 crimes, is the guilty one? Hey, Frederick Douglass, I know you're a slave and you're getting whipped and beat down and they're stealing your labor and your money and they've stole your soul and they're stealing your... But you're the guilty... Hey, I understand, J.C. Dugard. That man and that woman's raping you in the backyard, but you don't backtalk them, okay? It's you backtalking them. That's... You're not allowed to tell them to stop. If a cop arrests you for backtalking and they didn't know about the other stuff, the court is just going to fucking pile on J.C. Dugard even though she's getting raped in the backyard? That's ridiculous, and that's bullshit. That's like the 3 biggest victims I could think of. J.C. Dugard, Anne Frank, Frederick Douglass. The court held that neither the doctrine of separation of powers nor the generalized need for confident... Okay, I already read that. The court granted that there is a limited executive privilege in military, diplomatic affairs, state secrets, but they gave preference to the fundamental demands of due process of law and the fair administration of justice. So we need to get justice. The fundamental demands of due process of law and the fair administration of justice requires us to tell you, Nixon, that you got to give up your tapes. But Phil Greene, oh shit, he's got a photograph, but he can keep that photograph to himself. And then he comes up there, he's acting like he's the fucking law himself, or he knows the fucking... I mean, Gary Gonzalez owns that house. Michael Gonzalez, they got the same last name. These people are acting like they don't fucking know each other. It's right-wing sovereigns, a bunch of Nazis, and the fucking cops and the courts are protecting the Nazis. When I tried to ask Jacqueline Mitchell if she was a right-wing sovereign, they're going to object it, and he's going to hold up the objection. Why can't I ask him if they're a fucking... I hate Nazis. That's why we are fucking beefing, right? Oh, you're a Nazi hater? Well, you're not supposed to hate Nazis. We're supposed to hate everybody. You can't hate us. I sure as hell can. And then that totally tells you what the fucking the deal was. I don't like Nazis. They are literally Mein Kampf reading fucking Nazis. They are literally Mein Kampf reading fucking Nazis. They call the diary of Anne Frank the diarrhea of Anne Frank. That's who Jared Polis is fucking protecting. That's who Mike Gonzalez is protecting. That's who Soto Cruz is protecting. A bunch of fucking Nazis. And then when I would call the police, they would show up 30 minutes to an hour later and be like, well, where is he? They don't do a drive-by shooting and fucking stick around. And actually, sometimes they did stick around. They want to show that they run that fucking goddamn corner of Costilla County, so the cops would come in, they would hide for a minute, and then they would see the cop car leave. And then they would drive all the way around. And they're basically either telling me that they control that area. They'll respect it when the cops show up. They'll fucking lay low. Sometimes they would even drive out in the fucking field, go across to Rio Grande. The court held that neither the doctrine of separation of powers, the president must obey the subpoena and produce the tapes and documents. Nixon resigned shortly after the release of the tapes. Due process of law and fair administration of justice. Broad due process of law, when it comes to the fair administration of justice, is more important than your fucking privilege. Whatever privilege you're trying to claim, shove your privilege up your ass, Nixon. No, we're trying to get some due process of law here for a fair administration of justice. This is a criminal investigation, and it's Watergate, so they broke in. They fucking broke into the DNC, and they stole their fucking documents. I mean, that's like... Nixon's allowed to break into fucking actually, when it came to the Trump decision, they said that Watergate, they would have got away with their shit when it came to Watergate with the Trump ruling. But that's a major crime. You can't break into people's fucking houses and steal their goddamn documents. If anything, that's almost like some mafia shit, right? You keep on driving by, keep on acting a fucking fool when they go to the goddamn grocery store, then you just take their fucking documents. Now they have no constitution, they got no notes, everything that they worked on is all fucking gone. It's like they stole your mind, they stole all your work, your mind work, all your thinking work. Hobbes is just a brain, you know, when I think about all the stuff Hobbes has put out there. The public has the right to every man's evidence comes from U.S. v. Bryan, 1949, Blackmer v. U.S., 1932, and Brandsburg v. Hayes, 1972. Also U.S. v. Nixon, 1974.